Good afternoon. Welcome everybody to this anti-SLAPP conference and a conference on strategic lawsuits against public participation. And thank you everybody who's in the room. Thank you for everybody who's online, and thank you also to the great panel that we have here. We have Susan Coftree, who's the project director at the Foreign Policy Centre here. We have Per Egerman, who's a freelance journalist, investigative journalist, who's currently been sued in connection with work he's done with a Swedish investigative outlet, and we'll be hearing from Per about his experiences. We have Alex Papachristou from the Vance Centre, which is involved in supporting journalists against legal threats. And we have also, we're very pleased to have Jill Phillips here, who's the head of legal at the Guardian News and Media Group. And my name is Peter Geoghegan, and I am the editor-in-chief at openDemocracy. And I'm going to be your guide here for this afternoon's session, which is scheduled to run to about 5 o'clock. And we've got plenty to discuss, and please do put your questions in as we go, and they will appear on this little tiny screen. And if you see me squinting a bit, even though I've got my glasses on, it's me looking at the screen to try and find out what you've asked and what your questions are, and we'll try and get to as many of them as we can in the course of it. And if you're here in person, just put your hand up. There'll be a mic roving around, and you can we'll come to you and you can ask your questions. I must confess, this is a topic I have a great interest in. I am an investigative journalist, and I have spent many years being, it's fair to say, being slapped. Is that unfair? Does that work as a, I've had to deal with the threats from lawyers, from mainly often with defamation. There's a big issue, of course, for journalists. Even the defamation reforms of 2013 in England and Wales haven't done enough to assuage that. There's other aspects of just working, and I'm aware that you've spent a lot of time in this so far today talking about other jurisdictions, and this conversation will mainly be talking about the United Kingdom for a bunch of reasons that I think will become clear, and often mainly talking about England. But I will also put a shout out when it comes to things like defamation for other jurisdictions, other parts of the UK. I've often done a lot of work in Northern Ireland. I've been threatened with legal proceedings by Northern Irish politicians, which cost huge time and energy to my organisation. And one of the reasons that was able to happen is because there hasn't been defamation reform in Northern Ireland. Scotland is on the road to defamation reform. I've been involved in some of that process. Susan has too, in her capacity as a director of the Ferret, which is an investigative site that we set up in Scotland a few years ago. But again, there's a lot of issues with that for journalists. So the kind of way in which the law is used to silence and intimidate journalists is something that really is a daily aspect of being involved in, especially investigative journalism here in the United Kingdom. And it's particularly, I think, apparent in England, where it's just emerging as very much a favoured location for SLAPP. And I'm sure you've touched on some of the cases, some of the high-profile cases that have happened are currently going through our courts. Some fantastic journalists who've written fantastic books, written fantastic articles, exposing, especially London's role as a centre of global corruption, of money laundering, of reputation management, and they are finding themselves, and their publishers find themselves in the courts. What's also really striking, I think, is that journalists and writers themselves have been targeted personally, and that's happened to me in the past as well. And it's a very, very, very chilling experience when you receive a legal letter in your name. It's easy to use the land register to find out if you have a mortgage. It's not that hard to find out if you've that many assets, because if you're a journalist, you probably don't have many. And it's quite easy to figure out what the level of intimidation you might be able to silence you is. And so I think it's really important to kind of get a sense of just what a big problem it is, and how we can start to put this, I think, especially on the political radar. We have a lot of conversations and language in this country, especially from the party of government, that says they want to do things like tackle the role of dirty money in the City of London. We've got supposedly legislation coming on, things like Companies House reform. It's very, very slow if it's happening at all. And similarly, where's the kind of conversation that's going to happen around things like SLAPP and the use of England's libel courts to silence journalists? I think it's a huge problem. And I think, there's also, I think, kind of indications that there's a kind of almost like a larger hidden problem here as well, of UK law firms sending threats before there's even an official filing or anything, before you've even gone to someone for comment. We're already seeing that happening. It's happening actually in a story we're working on right now at openDemocracy, where we've had a number of legal threats from one of the big blue chip law firms, again, before you've even published anything, before before you've even gotten anyone for comment, they are engaged to try and stop you publishing. And I think it's, what I'm hoping that we're going to try and tease out in the next hour or so is both how this has emerged, what we can do about SLAPP, but also I think the personal experiences of people who are going through this and how it's possible to help people if there's remedies available both to us here in this room and listening more generally, but also what does a political remedy for this look like? What does a way in which we can end England's becoming this global centre for lawsuits that are specifically intended to stop people participating, particularly, and often I think it's particularly journalists from participating in the public realm. And to kick us off in this, I want to get Susan, who's here beside me. She gets the benefit of being the one next to me, so I'm definitely going to turn to her first to talk to some of these issues, Susan, and some of your work and experiences on it.
Okay, thank you very much, Peter. We started the Unsafer Scrutiny project due to another link to the UK, which is that we had seen that journalists in different countries around the world that were being subject to threats and risks were often writing about corruption that then somehow had a link to the UK. So the UK was facilitating it through its financial and legal systems, and the money was either ending up here or it was being routed here. So that was the initial intention of the project, was to try to establish what those risks and threats were, and we conducted a survey with investigative journalists around the world, 63 investigative journalists working to uncover financial crime and corruption in 41 countries responded, and while the vast majority of them were facing all kinds of risks, physical, digital, all kinds of harassment and things, the real kind of takeaway from that survey was just how much the legal side of things was the biggest concern. So 3/4 of journalists who were experiencing threats had received some kind of legal threat. And for me as a British citizen, the worst part of that was that the UK was really clearly the international leading source of those threats. So as the survey's actually been mentioned a couple of times already today, the UK, legal threats were emanating from the UK almost as highly as from EU countries and the US combined. So for us, that kind of really led us to question, well, what is making the UK so attractive? And amongst the other respondents to the survey was what is the tool that's being most frequently used, and that's defamation law. 91% of the respondents said that they had been subject to some form of defamation claim. And certainly, as Peter mentioned, there was reform of the law here in England in 2013, the Defamation Act in England and Wales, but it just seems that it hasn't gone far enough. There are probably three kind of main aspects which you can see continue to be a challenge. The first is cost. I think everybody who's spoken today has just spoken about how expensive lawsuits are to fight. And there was an Oxford University study that claimed that the cost to defend a case in the UK was 140 times the EU or Europe average. Now that was about 10 years ago, but I don't doubt that is more than likely still the case. The second aspect is the length. So again, we've heard that repetitively from different journalists today, just talking about how long cases take. Two of the journalists who will be speaking this evening, Claire Rucastle-Brown, who uncovered the 1MDB scandal in Malaysia, and also Paul Radu, who was sued here linked with work that he had been, OCCRP, the organisation that he co-founded, had been doing on Azerbaijan. Both of them had very similar cases. They were pursued through the courts for almost 2 years before the case even came to trial, and then the claimants withdrew the cases and settled. So you can think, okay, well, maybe that's positive. Ultimately, the legal threat was withdrawn, but that's after 2 years of expensive legal fees, of invasive disclosure procedures, of tying these journalists up in the amount of time it takes to deal with these issues and respond to the many legal procedures that you have to go through. And then I think the third aspect that doesn't necessarily get mentioned as much is the fact that in the UK the burden of proof is on the defendant. And since the defamation reform, that's a single meaning that the defendant has to prove, which is decided on by the judge. So it can sound fairly innocuous, but ultimately it's an inference that the judge has taken as to what that meaning might have been. And as Paul Rowdy himself said when writing about his experiences afterwards, journalists are in the business of presenting facts. How the reader takes from it is in their own mind, and to a certain degree that's subjective. But you can find yourself in a position where you are having to prove something you may have never explicitly written. And that can be very challenging if you're trying to utilise some of the defences in UK law, including the truth defence. And that's something we've seen that the investigative journalist Carol Cadwallader, who's currently being sued and has filed against her by Aaron Banks, the businessman, 2 years ago at this point, 2.5 years ago, and she's had to drop her truth defence, not because she doesn't believe in the things that she investigates and writes about, but because the legal meaning that the judge has decided upon in 2 of the claims, because there were originally 4, were not things that she felt she ever said or wrote. And very interestingly enough, there are only 2 claims being continued, and 2 of the original claims were dropped after the judge's legal meaning hearing originally. And at that meaning hearing, the judge said that those 2 other claims were far-fetched and divorced from the context in which the statements had been made. So a lot has been made of Carol unfortunately dropping the truth defence, and we've heard earlier about smear campaigns and online harassment, and I think she's experienced a lot of that as a result of reporting on that issue. But very little has been made, interestingly enough, of the other 2 claims where the judge said, well, you've gone too far with how you've tried to expand the meaning to be defamatory. So how does it work? Well, as we've sort of heard already from some of the journalists who've spoken, they all begin with legal letters. And so we think about the court cases, but actually that's the tip of the iceberg. And a lot of journalists, as you've just spoken about, receive letters, pre-publication, sometimes in response to asking for clarifications or for information, or just in right to reply. And it kind of seems to be diverting that process almost immediately into a legal one, and tying up the journalists and costing them money. I just wanted to touch upon a couple of things, particularly picking up on some of the points that were made in the previous panels, which was about access to justice and sort of access to information. And it's often said that, everyone should have access to justice, and that is an important principle and a democratic one that we should uphold. But it's not an equal system in the UK, and I think the costs are really at the key to that. It's not an equal arms. And Sean O'Neill, who was writing in the Times earlier this year about SLAPP, spoke about a financial sledgehammer to bully their way to victory. And I think it's very true. There is just no equality in the system. And coming back to the point that I was making earlier, that we were interested in investigative journalists who are uncovering financial crime and corruption, well, if corrupt figures are exporting their money out of wherever they have got them from, the many countries that we can consider to be struggling with that issue, they're often bringing it to the UK. And under the UK system, they are able to store their money here to buy property and what have you. They are able to access residency, citizenship, and establish a reputation. And then they've also got access to all of these legal tools and law firms that can help them manage their reputation. And if they are using those tools or misusing them to suppress public scrutiny into their wrongdoing, then we should be really concerned about how that is affecting justice and the impact it's not just having on journalists, but also wider society, and creating potentially vacuum of information where law enforcement agencies or others who would step in and investigate are unable to, because they just don't have the information to begin with. So I'll leave it there.
Thank you very much, Susan. Lots. I would add as well, they're also able to make donations to political parties as part of their constructions of reputations in London. One thing that really struck me there from what you were talking about, and talking about Paul Radu's experience that we're going to hear about later in the day as well, but was, is that the personal experience which I touched on, particularly if someone is a freelance reporter, or if you're, if someone goes for you personally, and the relationship between a publication and what you say about somebody is quite is not always clear, and even the way it's not, it's not always clear what legal insurance, where if someone's indemnified as a journalist or not, and people's insurance. I know our own insurance at openDemocracy went up threefold, our defamation insurance, when we wrote a piece about how someone had tried to sue us. When we wrote a piece about how Jeffrey Donaldson had sued us but hadn't served, we never got to court. And just by writing that one article, our insurance went massively up the roof, just by talking about this issue. And that's why I wanted to bring in Per now to talk about his own experience of this, and what his experience of being on the receiving end of SLAPP lawsuits been like.
I have no insurance, I can start to say that. Thanks for having me on this panel. My name is Per Agerman, and I'm a Swedish freelancer. When I listened to your the conference today and this panel, I immediately recognize very many things that I have experienced the last year. Not to say the letters from the law firms. We actually started to get those letters from the law firms saying that we have stated a lot of wrongful things, and we were asking questions about things that we shouldn't ask questions about and stuff. And we thought to begin with that, okay, we have to, this must be some kind of misunderstanding, or something must be wrong here. So we actually put together a long memo with all the facts, all the sources, the documents behind our question and behind the story we were planning to publish. And we sent that over to the law firm saying that, well, hey, this is our facts. We want some answers to our questions. And we thought that would make everything good, and they would start to actually try to give us information and give their side of the story, which we were, of course, were interested in. But instead, we got none of that back. We just got more threatening letters from the law firm. And this was in the fall, a year ago, in October. And actually, in a week's time, it's a year ago since we were served with this libel suit in the High Court. And why was that then, of course, you wonder. And I should start to give a background about myself and my colleagues that are in this lawsuit. I'm a freelance reporter in Sweden, and my colleague Annelie Östlund, we've been working together off and on for about 15 years on different investigative stories. And last year we started to work for Realtid. That's a small trade magazine for the financial and legal industry in Sweden. It's been around since 2004, but if you compare to the FT or Economist, we are really small. And we're published in Swedish. It's an online publication, so you can read it in other countries, but it's in Swedish for a Swedish audience. And we are looking at everyday things for us is like mergers and acquisitions, IPOs, companies doing some kind of financing rounds and stuff. We're also looking into a few financial crime stories and stuff also. But this is what we mainly do. And in the summer last year, we started to look into a network of Swedish stock promoters. They were selling shares in companies to Swedish individuals, saying that, hey, this is a really great share. You should get into this company before they go public on the stock exchange. So you have this marvelous chance of buying this so to say, gold in advance. And this is, we haven't said that this is anything criminal or anything. It's just a kind of gray market share trading, you can say. Looking into this network and what they were selling, we found a company, a solar park company called EEW. And they were also selling shares through this network then in Sweden. And we found this interesting because on their website, they were at the same time saying that they were in partnership with a big investment bank. And they were going to do a financing round of over 500 million euros and also putting a subsidiary on the Oslo Stock Exchange. So this was, for us, a very interesting piece or thing to look into, because normally you don't work with an investment bank while you at the same time sell shares, so to say, on the side to individuals in Sweden. So we started to do a really basic story, and this is what many people ask when they look into our case. They say, "Oh, so why are you being sued?" And we kind of ask ourselves the same question. The story is basically, you can say, it's a fairly basic due diligence story, looking into the company, who's in power, what have they done before, what are they promising, what are their plans, basic financial story about a company. And of course, we found quite a few interesting things in the past that we wanted to report on and so. And we thought that this was a good story, because we thought it was in the public interest to know that these share tradings were ongoing, and also what the company wanted to do. And since it was in the billions of Swedish kroner financial round, and they were going to go public with the company, we thought it was in the public interest. Nothing special really. But then when we started to approach the company and asking questions, quite soon we got, instead of returning with like answers from a PR agency or something, we got these law firm letters saying that we should don't proceed with this publication. And it was a law firm in England and also a law firm in Monaco, where they threatened with criminal proceedings if we were going to continue. And we asked ourselves again, is this worth going through with? Is this a good story for us? Does it have public interest? And we said yes on all that. We had a good, solid source base, a lot of documents. There were like really no problems, and we were not going to say that anyone were criminal. We didn't have any personal like scandal information. It was just a good piece about a company and the entrepreneur behind the company. So we started to publish in October and November, and we ended up then with being served. A guy came around with a plastic bag with a lot of papers and said that you've been served this defamation suit in London. So that happened a year ago, and we had a hearing in March this year, 2-day hearing. From our side, then we said that we don't think that this case should be settled in a London court. We don't think that they have a ground for that. So that is that question: what kind of forum should be used for this claim? Is it in London or is it anywhere else? Right now it's in London, and we say it shouldn't be in London. So we are at the moment we are waiting for the verdict in this forum question then. And I can tell you a little bit more about us. It's me and my colleague Annalie. We are freelance reporters then, and we are personally sued in this claim, and also our editor Camilla is sued, and also the company behind our magazine, the company behind Reality, or defendants in the case. And of course, it's really interesting to see the differences between the Swedish system and the UK system. If we would have been in Sweden, it wouldn't have been possible to sue me and Annalie personally. In Sweden, we have I think rather the unique model with the sole responsible editor. That's the foundation of the Swedish press system, where the responsible editor is the only one who are liable if you have a defamation case. And so this is of course a big difference between going to the UK or staying in Sweden. when you look into if you really want to say that we have published false information, libelous information, then Sweden might be a good forum actually, because in Sweden defamation is a criminal offense. You can go to jail in Sweden for publishing libelous information in a magazine. That's very rare, but it can be done in Sweden. But of course, in this case, they haven't chosen that route then, so they have chosen the London route. And I can just tell you a little bit about the Swedish system. Of course, we have this then criminal offense defamation in Sweden. On top of that, we have a self-regulatory model with a media ombudsman, I think like a press council, where everyone who thinks they are defamed or a victim of some kind of bad publications, they can go there, they can file a claim, and then the ombudsman looks into this, and you can have quite a long period with filings from the different parties. But normally this is to a very low fee. You could have a lawyer doing your filing, but of course it stays in a very low fee range, and eventually this leads to a judgment then from the ombudsman, the council, and if you lose as a media, you have to publish this verdict, and it also often leads to a public debate. That's nothing good. That's nothing that just put away. It's really out there, so to say. So I would say that both having this criminal offense to begin with, and then you have this ombudsman system. I would say that if you compare Swedish media to the UK media, I would say we are much more restrict when it comes to publishing names. We are much more any sensitive information. For example, if we have a suspect of a crime, that name is nothing that we're going to publish. We only publish names after we have the final so to say court decision in the case. So I think if you compare UK to Sweden, I would say that many UK editors would say that we in Sweden are quite conservative and moderate when it comes to publishing this defamatory information. So that's also good to have with you when you look at our case. So I don't know if I should continue. I can continue for a long time. But
thank you very much, Per. That's very useful, and maybe I think there's probably stuff we'd want to pick up on as well. Thank you for sharing that. It's actually also very useful, I think, to get in a kind of context of what it's like in Sweden, and it's also really striking. I think that you ended up having to fight cases in London and in Monaco as well, which I think has also made me wonder about
no case in Monaco, just a legal letter from Monaco.
Just in London.
No case yet. Yeah.
Thank you very much. It's very, very interesting, and I think it neatly leads us on to Alex from the Vance Centre, who's been doing work on things like legal defence for journalists and trying to help journalists in situations like this. Alex, could you, I wonder if you wanted to talk about your work and some of the issues that have already emerged and so far in the course of this session.
Thank you very much. I appreciate so much the invitation, particularly as the only non-European. Although when I say that, I realize that some of you may be former Europeans. I believe that I'm present really because I do a great deal of work helping journalists face threats and of lawsuits in the UK. You referred to Paul Radu's case. My organization and I personally helped Paul and his co-founder Drew Sullivan respond to the lawsuit in that matter. And I regret to say that there are several other similar matters that I helped them with at different stages in the UK. I've also worked with authors of books threatened with lawsuits in the UK, and other journalists. A Romanian journalist who posted only on his own website, didn't have an office. He worked from his apartment in Bucharest and wrote about an American public figure who's actually since been convicted of crimes unrelated to the reports that this man made. And the American public figure threatened him with a lawsuit in London. We have another matter right now where two people who self-admittedly live in Moscow are threatening a lawsuit in London. They don't even claim to have a reputation in the UK. So it is a real scourge, the threat of litigation in the UK. The only thing worse than the threat is the reality. I would characterize the phenomenon as having two key features: cultural and structural. The cultural would really have to do with legalism and internationalism, if you will. So the UK, and here's an American saying this, is a highly legalistic society. Much is dealt with through the legal system. Maybe the US is a more extreme case, but the UK has led us on the way. And the phenomenon of SLAPP is a result of this intense legalism in the culture of the UK. And internationalism, again, again, what's an American to say? But in the UK, there is a sense of somehow having a purview of the world. Whatever happens in the world is somehow our business. And that's how I think a lawyer in the UK feels no compunction to threaten somebody from Romania on behalf of an American figure with litigation in London. On the structural side, I think we're talking about formalism and Byzantinism, if you will. So the system in the UK is highly formalistic, and in this case more so than in the United States. There are more sort of strict rules to be followed, both procedural and substantive, and they inevitably mean a lot of time to go through them all. And they are convoluted, they are complicated, they are Byzantine. So there was reference to the legal meaning as a feature of UK defamation law. This is an absolutely artificial, man-made concept that you should be judged for your work not on what you meant to say, not on what any person would understand you to say, but what on a particular judge decides what you wrote means legally. And that's the statement that you're held against. But that statement is then held against the so-called Chase standards. And I hope nobody fact checks me too closely on this, because again, I'm a New York lawyer. But there are several layers in these Chase standards, and the legal meaning is meant to be placed at one of these levels. And then that makes the proof of the statement, as Susan said, by the defendant more or less difficult. So these structural features, plus this cultural attitude, if you will, produce what is really I don't know whether to call it an ecosystem or a monster machine that produces a high volume of threats and legal actions. There are many law firms, it seems, that derive all of their business from this defamation industry. And judges are specialized in it as well. That's, I think, an unusual feature. I can compare it to the US system. I can compare it to, unfortunately, to the Swiss system, the Cypriot system, because my clients, OCCRP, ICIJ, and members of the OCCRP network in Serbia, in Montenegro, in Bulgaria, all have had threats in the UK, and lawsuits in other countries as well. So what to do about it? I think that my sense is that the only solution is legislative, and the question is the political will to control what I think is certainly hand in glove with the reputation washing industry in the UK and the money laundering industry in the UK, as others have said. The defamation industry serves those other industries and vice versa. It is wealthy people and companies of questionable repute who can afford and morally manage paying lawyers to bring these cases, and it is it's a matter of political will and political pressure. I had the occasion to speak to some people in the National Security Council staff in the Biden administration. It sounds very fancy, but it wasn't. They said what was one thing that they could push for to improve conditions for journalists around the world. And other people spoke and they said, well, we have to speak up strongly about the importance of journalism. We have to rise to the rescue of journalists when they're attacked. I said, in the US-UK trade negotiations, the US should insist that the UK reform its defamation laws, because those laws hurt free press, free expression, and those are values that apparently, purportedly, are dear to the United States. I'm not sure that means of exercising political will work. However, I do think that the solution somehow lies at that level, because there's too much self-interest in this system, isn't there? Too much money to be made by people willing to take advantage of the laws and procedures that exist, and too many people with too much money willing, therefore, to spend it for no good reason other than to harass, distract, and deplete the resources of journalists and other reporters. I could tell some more war stories and spout some more theories, but I'll stop and await questions. Thank you very much.
Thank you very much, Alex. Yeah, and I think it seems to be featured. Lots of us on this call have probably got lots of war stories that we could talk about, and I'm really struck as well by what you talk about there, the enabling industry, the work of reputation management, the whole world of kind of corporate espionage that feeds into that, and of law firms and libel for lawyers who make a fortune from it. So I think all of those constellation things that make up this, and that question of why London, why is England the capital of SLAPP. But before we talk about that a bit more, I think I'm sure she has one or two war stories too, but I'd love to bring Jill Phillips in from The Guardian to kind of to give her contribution on some of these issues. Jill, are you there?
Hi, can you hear me?
We can indeed.
Excellent. Thanks very much. And I'm very conscious that people have had quite a long day, and they've had a lot of speakers. And while I don't want to repeat what others have said before me, I don't take any shame in doing so, where I feel it's so important to echo what other people have said about the current blight, or as Alex said, scourge on freedom of speech. That, while global, and we heard some pretty horrible stories this afternoon from the two sessions from Europe and South America, but there does seem to be a particular problem in the UK here, and it does seem to focus on the courts in England and Wales particularly, although as you've just said, there are also issues in Peter, in Northern Ireland, where the Defamation Act 2013 hasn't yet come in, and also we've been finding threats now that because we're not in Europe, we're getting threats. Well, we're going to see you in Dublin. We're not going to engage in Europe, or we might see you in both. Which is probably the worst nightmare that you could think of. But and I think an indication of that is the fact that on the Panama Papers, it was the BBC and the Guardian that were sued by Appleby. Notwithstanding that they were both part of a much larger consortium, that it was an ICIJ project, but they come to us to try and get some documents, and because of the reasons really that Alex has so eloquently articulated about the sort of structural environment that there is here around the law and the way that the processes operate. And on one hand, we sing the praises of the UK courts because they're clear. What the rules are. You're not going to get ambushed, but they are very expensive, and that can be exploited by people. So I think that there is an issue here, and that's not to play down again some of the stories that other people touched on earlier about the harassment and the physical and other threats that are going on around the world. But when the law is at the heart of it, it is very worrying that can be used as another weapon in the same way that these other things are. So I think from my perspective, what we see these days are really two main ways that the of UK media intimidation. The first is the pre-publication experience, the weaponizing of that process, which sort of started off life as an ethically fair, good practice, whereby a journalist would send a right to reply letter or an invitation to comment to the person that they were writing about. Sometimes they would do it as part of their investigation, so they might do it quite early on to try and find out some more information, or they might do it to give them a comment at the, towards the end of the process. And what increasingly they get back, as others have said, is a very threatening letter that is headed not for publication, is headed private and confidential, is often contains 2 or 3 pages of, if you get this wrong, beware, we are going to come after you. You will find that there is no stone under which you can hide type approach, which of course has a very, very chilling effect, particularly I think on freelancers, on foreign news organizations who aren't used to the sort of rules and the regulations in the way that maybe Guardian and other UK news organizations are, because we've had to be. But it's sort of somehow turned around what's supposed to be an ethical good practice for journalists into a battleground before you even publish. And quite often you get these letters, and sometimes they don't even answer the questions that the journalists asked, or they start throwing flack and smoke screens around about, well, you haven't given us enough information, you need to tell us this, and you need to tell us when you're going to publish, sorts of things that actually there is no obligation to do. So it's that of itself, I think, is a very worrying practice, and why people can't just answer the questions that they're asked, because most journalists know if they get it wrong, there is going to be a consequence to it. So throwing pages of court cases and quotes from this, that, and the other, is not great. And then the second area obviously is the post-publication, either the threat, the letter again that comes back, again with 2 or 3 pages that says, you've got this wrong and that wrong, and we're going to come after you in a very aggressive way, as opposed to trying to sort of resolve it. And part of the problem that is exactly what Susan's highlighted and Alex has highlighted, which is this mismatch between meaning and evidence. And you get caught out if the meaning is not what you thought it was or what you intended. It's a higher meaning, the chase levels 1, 2, and 3 that Alex was mentioning. And you think you're at the bottom end, and actually you're found to be at the top end, which is often what happens with the claimant lawyers. They'll say, you said our client was guilty, and you're going, no, I didn't. I was just asking questions about what they were doing. And that mismatch can completely catch you out. And that may not be intentional at all. So that side of things, I think, is problematic. And then, of course, from the threat of action of itself can be quite damaging through to the actual commencement of actions. But you don't need to commence the action to have, again, the chilling effect, and to cause the difficulties. And again, in some cases, it's not about the outcome. It's just about the utilising the legal processes, the time, the cost, etc., to drain the time and financial resources. And I think that, again, Susan said right at the beginning, 91% of their when they looked at this were defamation claims. But it's not just defamation claims that are being deployed these days. It's privacy cases. Quite a lot of data protection is now being used, and I think we're increasingly finding that data subject access requests are being used both before and after publication, which, if anyone has ever done one, and even though there is a journalism exemption, you still have to do all the searching and the looking and checking that the exemption applies. They can be incredibly time consuming and costly. And you sort of think, well, why are they doing it? They know that someone's going to write about them, and if they're doing it before publication, they're doing it to try to divert you and stop you writing about them. And if they're doing it after publication, when you're a journalistic organization, they can only be thinking that they're going to just be malicious about it. It just feels malicious to me when it's done. I mean, maybe they think, well, we'll find some little niche where the journalism exemption doesn't really apply, and we might get some document out that might help us down the line. But where journalism and free speech is concerned, and where there are court processes that, if you sue, allow you to get disclosure, that feels like an abuse to me. I think it's very worrying. And then when you add into that, the fact that it's quite easy to start a libel claim in the UK, it doesn't take much. I mean, the Defamation Act helped, the 2013 Act, with serious harm coming into play. I think that's made a difference to corporate entities suing for defamation, and they can't sue for privacy or data protection. So, that is, I think, a better place for us theoretically. But you've still got the burden of proof problems that have been touched upon, and again, how that feeds into this difference, this problem around meaning. And in a way, just as a sidebar, for the Guardian, we've got lawyers that look at things before we publish. And we're trying to deal with this meaning issue, and we're trying to make sure that we are matching what we've got evidence-wise to the meaning. But for people who don't operate in our environment, that's a foreign thing. They're not going to be thinking about it in that way at all, let alone a freelancer who thinks, well, I'm writing about this, and can get caught out very easily by it. So I think those things make it an uncomfortable place to operate in. And then you've got the costs of the lawyers, £600+ an hour for claimant lawyers. You've got this set of boutique firms who are there to do reputation management or washing, as others may call it. They're specialist firms. They're set up Some of them, some of them have loads of people who aren't just lawyers. They're doing all sorts of things on Google and technical things to change things and move things up and down Google and, all that sort of stuff. So it does create, as Alex said, an environment that structurally and legalistically allows people to exploit it. And at the moment, there aren't really enough safeguards in it that allow the defendants to fight back. And you may well have a defense, you may well succeed in a truth defense or a public interest defense. But as we've heard, it's going to take you possibly 2.5 years and maybe £500,000, £1 million, with the risk that if you lose, you're going to be paying double that and damages. So, I'll leave things there for now, and we can touch on whatever as you wish to.
Thank you very much for that, Jill. Yeah, and I think a huge amount of food for thought there as well about the fact that it's not just defamation. I think it's easy to think of SLAPP as just defamation and that's the only thing you're thinking about. But there's all these other ways of getting engaged. And we've seen it with journalists, especially with subject access requests, which, as a journalistic tool I've used myself many times, but we've seen people use subject access requests against journalists to try, we had it with the Benny Steinmetz case here in London as well, an attempt to silence Global Witness and their investigations against him, and it seems to be an issue that's becoming more and more prevalent. I'm dealing with them more and more in my work too, people sending in subject access requests, and it feels as if it's part of this process of trying to intimidate you out of being involved in participating in public life, frankly, and writing things that people don't want to hear about. I'm conscious actually that there's a lot of people who might want to ask questions. I'm also conscious a few questions have come in on this little tiny screen, so I'm going to have to squint forward to read them if you don't mind, just for a second. But also if anybody hears a question, there is a microphone, so I'm going to suggest anyone might want to put up their hands if they have any questions and a mic can come to them. One says a comment, not a question, which feels very much like at least in England and Wales, it's possible for winning defamation to recover some of the costs, and there's an effective limit. This is from Nicola. There's an effective limit on general damages, unlike the US where costs are irrevocable unless there's an anti-SLAPP suit you can use, and extremely high, and damages are virtually unlimited. So the US isn't great, and they still have the court determining meaning. A question here from Mona. In a world of fake news, is it nonsensical that fact-checking journalists are left fearing SLAPP while others get away with complete fiction? How to address that? I think I'm just going to read the comments here, and we can maybe use them as a tipping off point. Is an organisation that's simply quoting investigative reports to lobby government and organisations to act against corruption, such as Human Rights Watch? Are they as much at risk of SLAPP as the journalists and the publishers that are the source of the story? Or is SLAPP a punishment by process? Are they equally exposed anyway? Examples. I think some ways all of those comments kind of speak, I think, to kind of some kind of similar overarching, I think, concerns about the way in which, people can be penalised simply for reporting things that have happened. And we've seen this, and I'm sure maybe Alex has got some experience he wants in this area in particular, but it feels as if there's, this is the chilling effect, really. I was coming down the hallway, I'm not betraying any confidence, I'm sure, Susan, we were talking about, what can we say about court cases that are already ongoing, that are already in the public domain? I was talking about SLAPP on the radio this morning on Radio Scotland, the BBC, and similarly, you are thinking, well, what can I say? Where do I feel like my boundaries are? And I think there's a chilling effect that has as well, even talking about issues that are subject to a court case. And you see it runs across the media. I know if I write a comment piece for somebody, The Guardian, and I write about a current case, everyone gets to understand, everyone gets to call it chilling effect, because you get the chill down your spine going, will they come for me too? Will I have to deal with this? So I kind of, you can see how this snowballs. It's not necessarily just one person. It can snowball right through into even just discussing the kind of issues that are there. And so I just want to kind of throw that, that's as much of a comment, less a comment, more than a question out to the audience too, I guess, a bit. Alex, what's in your line, in the work that you've been doing, how have you seen this sort of stuff play out? The kind of, because say the Paul Radu case, which wasn't written about all that much in the UK, do you think that the concerns around someone going for you just for reporting what's happening is part of that?
Well, absolutely. And that case actually serves to illustrate several key features of the UK litigation machine. So Paul himself was not an author on the stories that were the subject of the litigation. He tweeted about the stories, and then there was a claim that he was an editor, but that wasn't ever substantiated. He was the only one sued beyond the initial stage because he was an EU citizen, is an EU citizen. And this was before Brexit, and the Lausanne Treaty enabled him to be hauled into court. OCCRP itself could not be sued so easily because it's not present in the EU. So that's one feature. And I must say that Brexit was, in many ways, the most important reform to the threat of defamation litigation against everyone except those lucky enough to live in the UK that there's been. I think Per's action is probably somewhere stuck in the middle of Brexit, and he probably can't talk about it for the reasons you said. Another feature is to distinguish the UK from the US, for example. Somebody mentioned, isn't the US more expensive? Well, in the UK, you can be charged for the costs of attorneys on the other side of the case during the proceeding. So if you make a motion to dismiss the case, as Per has done in his case, and the court rules against you, you immediately must pay the legal fees of the other side. That's not the case typically in the US, or to my experience anywhere else. And that is sort of an immediate burden, financial burden on you before the case gets 2 years down the road to the trial. If you then win on the trial, you get that money back. But that's not much solace if you've had to pay it up front. So that's another feature that the Radu case showed. And then the third has to do with what we call in the US discovery. In the US, you can ask just about any question and demand just about any document of the other side. So if you're sued as a journalist, you can use the case to continue to investigate the matter that you had published about, and very effectively, much more so than if you're just a reporter. You can put people under oath. You can insist that they give you all of their documents, and everything that you get in most cases is immediately public. You can write about it right away. May not be a good idea from a tactical point of view, but you can, and other people can as well. In the UK, there's much more limited discovery. You're much more constrained in what you can ask. And then nothing that you find out during the trial is public until the trial, and until it comes out in the trial. Jill may correct me on all of this, and I defer to her, but the result is that, again, the process keeps going until the trial. There isn't something along the way to slow it down. And in the Radu case, what happened was that OCCRP just did a fantastic job over those 2 years awaiting the trial, finding out more than it had originally published. And they had terrific lawyers, Jonathan Price of Doughty Street Chambers and Chris Marks of Weil Gotchell. I'm going to shout them out because they did this largely on a pro bono basis. And that obviously was another key feature in that case. But the claimant dropped the case at the final hour. Why? Because he could not stand the idea of what his lawyer told him that OCCRP would put forward literally 3 days later would become public. They had uncovered enough that it was worth it to him not only to drop the case, but to drop it very favorably to OCCRP. I can't comment specifically, but very favorably to OCCRP because of what they had found out during the case. So those I think are specific features of that of that case that show some elements of the UK defamation industry. Jill, please correct me if I got anything wrong.
Nothing wrong, Alex. I mean, no, I agree with you. I mean, and we do have these very strict laws on what you can disclose when you've got disclosure in litigation, and indeed, it can last even after the case if the papers aren't referred to in the court process. They're just disclosed for the purposes of the litigation and can't be used anywhere else. So that doesn't work as a threat per se, in the way that it can be used in the States. And I was just to pick up on a couple of points from what Alex was saying. I mean, I had to legal some of the Guardian stories arising out of the Forbidden Stories project from Daphne Caruana Galizia. And it was very, very difficult legaling those stories in the UK sense. One, if you started talking about SLAPPs in that context, you were already suggesting that that lawsuits might be vexatious or abusive, i.e., that there might be nothing in them. So you were trying to work out a way round how you could talk about this without putting yourself at risk. And likewise, I think you had Nick Cohen on earlier, and I had to legal Nick's. Well, I was involved in the legaling of Nick's story about the Putin Papers episode, and that was very, very tricky because he wanted to say, it's a SLAPP and whatever, and you're going, well, and as he said, I think, he was made to be very nuanced, possibly more nuanced than he might have wanted to be about it. And it does feel very odd that in these cases where this is a public discussion, this is very, very rich people doing things, using the courts, using process. And the fact that we can't even talk about that without worrying about it, let alone the cases themselves, just shows you what a stupid place we're in at the moment. And a stupid place that's very expensive, very chilling, and is a big problem.
Thank you very much for that, Jill. I see we have one person in the room. I feel like I should defer to the room for once rather than the laptop.
Thank you. My name is Mary Myers, and I'm researching the UK's Global Campaign for Media Freedom, the Global Coalition. So this is a campaign that's being led by the UK, yet we're hearing that we're in a stupid place in the UK for this terrible practice of putting SLAPPs on journalists and using UK firms. So I wondered whether anyone on the panel or up here in the room could say what, if anything, has the campaign that was launched by Jeremy Hunt in 2019, what, if anything, has the campaign done to address the problem of SLAPPs against journalists, whether internationally or nationally here in the UK?
Thank you very much. It's a very, very interesting question. And I just have flashbacks of a headline of Jeremy Hunt standing somewhere saying this, and I totally forgot about it. It could have been, which maybe says more about me than anything else. But can I just put this out to the panel? Is there anybody who has any kind of comment or engagement with this global campaign for media freedom that the UK has launched?
Aside from when it was launched, it inspired me to start this research because I was very glad to hear that the UK was setting this aspiration, and I think it is an aspiration and an important value to promote globally. But initially I felt there was a strong disconnect in understanding the role that journalists play both here and also in countries which are less than democratic and are not promoting media freedom domestically, and a lot of that power comes from their ability to send their money through UK financial systems, and if they can't crack down on the journalist at home, they can sue the journalist abroad. So I think we need to be really aware that that process is happening, and the more that the Global Media Freedom Campaign can speak out about it. I mean, it's really great. We've had the engagement of the high-level panel who are really taking up the issue of SLAPPs, and we're going to hear tomorrow from Professor Milo in the morning talking about the work that they're doing on SLAPPs. So it's very encouraging. I do think the conversation is growing, but I think the UK has fallen behind as it stands in terms of the initiatives that are evolving in other places. We've heard a lot about what's happening in the EU at the moment, and given it's been identified as a sort of leading international source, it really has an opportunity to play a leading role in pointing it out and taking actions to redress it. And some of the countries that are members of this coalition include the ones we've heard from journalists today. Cyprus, for example, we had a journalist here earlier, and Cyprus is a member, so it would be great for those conversations to be happening at that level.
If I could just intervene.
Yeah,
Alex,
sorry, please do, Joe.
No, please, Joe.
Alex, all I was going to say is I think there's a slightly imperialistic colonial approach to this from our side of things, which is that we're up there saying you're all behaving badly and we're going to give you a good example, and we're not looking enough at our own internal side of things.
Exactly.
Yeah, there's a huge parallel. I'm very pleased that Susan mentioned corruption. I do a lot of work in the corruption space, and there's such a huge parallel between this and the kind of the UK's rhetoric around corruption as well, while facilitating massive amounts of corruption through the City of London and even allowing the corruption of its own body politic. So no, I think it's really I completely agree, Jill. Is there Alex or Per? Is there any point on this you wanted to raise?
I was just going to say that if I understand the global campaign, and I'm again looking at it across the ocean, it may be that my little NGO received some money through UNESCO from the global campaign to fund the training of journalists, and we're training the members of the OCCRP network in how to confront the threat of defamation in the UK and the US. And what I wanted to use that as the point to make is that it's about money, right? It's about resources, and if the UK would fund lawyers to defend journalists, editors, reporters threatened with defamation suits, you would immediately start to adjust the scale. I know that there was opposition in a previous Conservative government to encouraging law firms in the UK to do pro bono work, because the idea was that would undermine people's willingness to fund legal services through taxes. That if the law firms would somehow relieve the moral burden on the wealthy to fund legal services. Well, by that somewhat convoluted reasoning, it seems to me that we could make the case to fund legal services for journalists, specialist lawyers to defend journalists and others threatened with defamation actions, whether they're in the UK or they're in Romania or Bulgaria, for that matter. So, that would be a real solution that would start to adjust what is at its heart really a gross financial imbalance.
Thank you very much, Alex. I'm aware the time is ticking. I don't know if there's more questions, I might take my own chair's prerogative to ask one question, but I'll take another question here before I do that.
Whether it's going to a different forum or shortcutting through, an early decision in any court case, because basically once you take the money out of it for the lawyers, you're rectifying things.
Yeah, and in many ways you've stolen my final question, which is what can we do about this, guys? And I think no, and you've stolen it far more succinctly than I could ever have put it. So I'm going to throw this out there, and I think that specific, excellent, very specific question, and more generally, like if we think about it, the organisation I run, we talk about challenging power, which is writing these stories, but the other thing we talk about is inspiring change. So how do we change this? What does change look like? So Susan, you're sitting next to me, so I'm going to get you to start, but I think this is a very, very important intervention that we can probably try and hope to speak to a bit.
Well, I start by saying I'm not a lawyer, but since the beginning of this year, it's already been mentioned, we've set up an informal group working on SLAPPs in the UK, and there have been a few roundtables that have taken place and some proposals kind of drawn out and looking at what we can possibly do. It'll be properly announced tomorrow in detail, so watch this space. But I think it echoes some of the similar points we've seen elsewhere, which is we'd like to speed this process up. Get to a point where these issues are not taking 2 years and loads of money and pushing people into the ground, journalists into the ground, taking their time up. And I think an important point is to make that would be a more equitable system for everybody. So it's not to say that all journalists are right universally, and they don't get things wrong and they don't defame people, and there are many people who are subject to genuine things that have damaged their reputation and can harm them, but they don't have the same access to a remedy because they don't have the legal funds to take legal action. So I think what we'd like to see is a system that works best for everybody.
Thank you very much, Susan. I might throw this out to the rest of our panel. There.
I wonder whether Per wanted to say something, having experienced the actuality of it.
Yeah, since I'm in the middle of it, I'm still looking forward to what's going to happen in my case moving forward. We of course have no problem with defending our stories in the High Court. We look forward to do that if we need to. And I've been through several judgments from the High Court, and I think they are, for me as a non-lawyer, native English speaker, I can read them. I can understand how the logic behind it. I think they seem to be fair in many ways. And also, I mean, many of my role models as journalists and newspapers are English. I mean, FT, Economist, Guardian, BBC, they are all great medias with a lot of great journalists. They've been around for over 100 years. They have survived this Defamation Acts in their different stages. So I have high hopes, but I think, as you said, Susan, if what we all want is better journalism, we don't want libelous stories. We want correct facts. We want to report the right way, so to say. And if you, of course, there should be consequences if you do something wrong. If you defame someone, there should be consequences for the medium. I think that's fair, of course. But you have to speed up, as you said. You have to, if that's achieved, you could arguably say that it might be a better system to reach that conclusion or ending. But I'm looking forward to win the case. So that's my end point, maybe.
Thank you very much, Per. Jill, do you want to comment on that? Oh, sorry.
Yeah, well, I think, Alex, in fact, I'll be very short. I mean, one of the things that we're discussing is trying to introduce some of the anti-SLAPP measures that they've got in the States, the procedural safeguards, so that where you have the sort of case like Per's case, or there's a Spanish case, I think, like quite similar going through, any case where you want to say, look, this is really about speech, that you divert it off into some sort of different room where the burden of proof is suspended, where there is an accelerated process and the court looks at it as a whole in a managed way financially that happens quite quickly and says this case is not going any further, or it is going to go further, and at least then everybody knows the wheres and wherefores of it at that point, and with some sort of cost sanctions or whether on damages. One of the things about the difficult things for defendants, if you win a libel case, is yes, you get your costs back, not all of them generally, but a proportion of them, but you don't get any damages, or you don't get anything to sort of reimburse you for all the extra stuff that's gone on around it. There's nothing like that. So it's speech we're talking about. It is, as Helena Kennedy said this morning, in a fundamental part, a key part of democracy. And so there should be sanctions in those cases, cross sanctions of damages, or some sort of standard award that you get within a procedural room that allows it to be properly explored, the pros and cons of the action.
Thank you. And Alex, I'll give you a quick last word on this, if you may.
Sure. I would strengthen the burden on the lawyers filing the lawsuits. First of all, to know their clients, to know that the money that their clients are paying them is not ill-gotten, the way a bank is supposed to check before it opens a bank account. And second, to verify their good faith belief that the claim they're filing is well-grounded in the law. A lawyer should not be able to take dirty money and file a vexatious lawsuit and earn a legal fee and walk away from it richer as a result. So that's where I would put some pressure.
Thank you very much, Alex, and I think amen to that is probably what most people in the room can say. Yeah, thanks a million I just want to say thank you to all of our panelists who've been absolutely fantastic on this, to Susan, who's next to me, to our three panelists, Per, Alex and Jill, who've been joined down the line. I think it's been very impressive, seamless Foreign Policy Centre management of the Zoom call, so thank you to everybody. And I also want to say there's going to be an hour's break now before the evening event, which is going to be Edward Lucas in conversation with Claire Rewcastle-Brown and Paul Radu. So for those of you who are here in person, so that's me and Susan, and the rest of you, there's going to be drinks upstairs. For everybody else, you can continue, it'll all be viewable online from 6 o'clock at the same link that you have. And yeah, just a final thank you again to the fantastic panel that we've had here today to talk about this.
Thank you.
Thank you. Thanks.